Good afternoon. My name is Rabbi Shlomo Weissman. I serve as the Michoel, the director of the Beth Din of America, and I'd like to thank you all for joining us. We're going to jump right into the webinar today. First, Rabbi Michoel Zylberman is going to talk about the Jewish law issues, and then Professor Chaim Saiman will talk about the secular law issues. And after that, each of them might chime in and respond to each other's presentations, and then we'll jump to question and answer. You could enter questions during the course of the webinar by just clicking on the Q&A option on the bottom of your screen. And for those of you earning CLE credit, we'll be sending out a form after the CLE asking you to enter the password. At some point during the CLE, we will announce the password for you to enter. I think it's important to note at the outset of this that this seminar is taking place in the context of a global pandemic where a lot of people are sick and suffering, and we start by wishing a refuah shlema to all those who need it. We'll end the webinar at the very end with a recitation of a parak of Tehillim in the zechus of all those people and in hopes and prayers that they enjoy a speedy recovery. Okay, let me first introduce Rabbi Zylberman. Rabbi Michoel Zylberman serves as Sgan Menahel of the Beth Din of America. He also serves as a dayan there, sitting on cases, and on a day-to-day basis, he oversees all the halachic aspects of the gittin practice that we do. He oversees those gittin as the Mesader Gittin, and he also serves as on the academic faculty of RITS of the Rabbi Isaac Elchanan Theological Seminary, Yeshiva University. And it's my pleasure to turn the microphone over to Rabbi Zylberman.
Thank you, Rabbi Weissman. I'm honored to be with you all today, even if I can't see you, but I trust that you're there, and I hope that you and yours are all safe and healthy in these trying times. Before we begin our presentation about the Jewish law perspective on canceled rental and employment contracts due to an epidemic or pandemic, I would like to make two brief introductory comments. There's a story about the Beis HaLevi from the time when he was the Rav in Brisk, in which two Balabatim approached him to resolve a dispute regarding the ownership of a piece of land. After hearing both sides, the Beis HaLevi reportedly said, "We have heard what both of you have to say about the land. Now let's hear what the land itself has to say." Beis HaLevi put his ear down to the ground and then remarked to the litigants, "You both say that the land belongs to you, but the land says that you both belong to it. Ki afar ata ve'alafar tashuv, for you are dust, and you will return to dust." As all of humanity, and perhaps some of our communities in disproportionate numbers, are suffering from this horrible virus, we realize more than ever that HaKadosh Baruch Hu runs the world, and that ultimately, in the words of the Beis HaLevi, we all belong to the land. While we will be focusing in this presentation on financial matters, we understand that in our value system, the few $100s here or there that may be in dispute are of little consequence relative to the life, health, and safety of ourselves and our loved ones. May we all experience refuos v'yeshuos quickly. As a second introductory comment, we should just know that Dina de Malchusa Dina, a deference to the law of the land, may play a significant role in determining the bottom line of many applications that we will discuss. This is true both regarding terms governing contracts and collecting monies owed while other legal remedies exist. So for example, even in a case where halacha may award lost wages to an employee, if that employee is able to collect unemployment, he cannot double dip, and the employer would be off the hook for those funds provided by the government. In halacha, in most situations of both rental contracts and employment contracts, if an ones, an unanticipated situation that prevents fulfillment of the contract arises, the terms of the agreement are still binding. However, the Mishnayos in Bav Metzia, Kuf Gimel Amud Beis and Kuf Hey Amud Beis introduced an exception to this rule. The Mishnah tells us on Daf Kuf Hey Amud Beis in Bav Metzia, Hamekabel sada mechavero v'achla chagav o nishtafa. If a sharecropper entered into a sharecropping arrangement and the field that he was supposed to work on was destroyed by a swarm of grasshoppers or an unanticipated storm, im makas medina hi minaka lo min chikuro, im eina makas medina ein minaka lo min chikuro. If the destruction was attributable to a makas medina, an unanticipated event that affected the majority of fields in the area, the sharecropper is not responsible for the unrealized output. If the damage was of more limited scope, then the sharecropper is still responsible. As Rashi explains, a limited event could be attributed to mazla garam, to the bad luck of the affected party, as opposed to a makas medina, a plague that afflicts a large number of people. Beyond the makas medina exemption for sharecropping arrangements, which Shulchan Aruch quotes in Choshen Mishpat, Siman Shin Kaf Aleph and Shin Kaf Beis, the Rama, in his glasses to Shulchan Aruch, invokes makas medina in the context of property rentals, Siman Shin Yud Beis Seif Yud Zayin, Shin Yud Beis Seif Yud Zayin, and in the context of employee contracts, Siman Shin Lamed Daled Seif Aleph, Shin Lamed Daled Seif Aleph. Examples of makas medina addressed in the early responsive literature include that of a city burning down, which we'll get to in a few moments, a garrison of non-Jews that takes over the majority of Jewish homes in a city, government edicts restricting commerce or education, epidemics, and war. In recent years, makas medina was raised in the context of the Gulf War, the Second Lebanon War, and Operation Cast Lead. So let's discuss for the moment the application of makas medina to property rentals, and then we'll move on to discuss employment issues. The Rama in Choshen Mishpat, Siman Shin Yud Beis Seif Yud Zayin, Siman Shin Yud Beis Seif Yud Zayin, discussing a fire in the city, writes, Nisraf Kol Ha'ir Have Makas Medina. If the entire city burns down, that is considered a makas medina. Umenaka lo min schiruso ma shelo darbo. And in that situation, a landlord is not entitled to collect rent for the days during which the house was uninhabitable. Bein hiktim lo secharo olo, whether or not the rent was prepaid or was not yet collected. According to the Rabbi here, quoting from a Chuvas Maimonios, Mishpatim Siman Mem Zayin, rules that since the landlord is unable to provide the residence that he had committed to providing, he is not entitled to collect any rent. Does the same rule apply in a situation where the house is still standing, but may not be easily accessed due to a war or an epidemic? If someone rented a house in Florida for Pesach this year, but was unable to use it either because of travel restrictions, fear of contagion, or perhaps a state ban on short-term rentals, is he entitled to a full or partial refund? May the landlord counter that the house is in perfect shape, is fully inhabitable, and therefore he, the landlord, is entitled to full payment. There appear to be four approaches to addressing this question. There's a tshuva of the Ravan, one of the early Bali Tosfos, Siman Sariches, who addresses rental payments in a situation in which the majority of a city's residents were forced to flee, and payment for a long-term rental had already been advanced. Upon his return to the city, the tenant demanded a refund for the months that he had been away. Ravan does not explicitly write what the cause of the flight was, but when Machan Ephraim, one of the great achronim of the early 18th century, quotes this Ravan, Schira Siman Zayin, he presents it as people running away from a plague. Be that as it may, whatever the cause was, Ravan rules that in this situation, both parties, both the landlord and the tenant, share the loss equally, meaning the landlord is entitled to half of the rent for the period in which the residence was unoccupied. As opposed to the case of the flooded field, where Makas Medina only affected the field, which was the sole property of the owner. When a Makas Medina causes the residents of a city to flee, both the landlord and the tenant are equally affected. In the words of the Ravan, Aval Hacha Ikol Neymar Gezeras Hamaka Al Shneiam Haisa. In this case, the Makkah affected both parties equally. Alabatim Lios Bedudim. The houses were destined to be desolate. Anashim Lios Golim. And the people were destined to be exiled. Hilkach Lasa Dishneam Hu Yachloko Hefsa. Therefore, both of them are equally affected by the plague, by the Makkah, and each of them shares the loss 50-50. Machan Ephraim, following a brief citation of this Ravan, quotes a Yerushalmi in Gittin, Perek Vav, Halacha Vav, regarding a person who rented a boat to ferry him across a river and prepay the rental fee. However, before the person actually used the boat services, the river dried up and there was no longer a need for the boat. Rav Nachman ruled in this case that the renter was entitled to a refund. Machan Ephraim, in his analysis, explains the following. The Yerushalmi rules that the renter was not entitled to a refund. Machan Ephraim explains as follows. In halacha, we assume that ein schiras mishtalemeth ela lebasof, that rental fees are only payable at the end of a rental period. If a person pays for a rental on a monthly basis, according to halacha, payment is only due at the end of the month, not at the beginning. That being the case, if a renter chooses to advance payment, which he was not required to do, he indicates that he's comfortable with the proprietor retaining the funds, even if the services prove not to be necessary. So if a tenant prepays a rental fee, according to Machan Ephraim, as long as the property is still standing and technically inhabitable, the tenant is not entitled to any refund, even in a Makas Medina situation. This is in distinction to the case of the fire, where all the houses in the neighborhood burned down, and the landlord must refund any payment because at the end of the day, he's unable to provide a house to reside in. In all likelihood, the Machan Ephraim's logic would not be as relevant and hold in societies like ours, where rental fees are always paid in advance of the rental term. That is the industry standard, and the person doesn't have the option in most situations of withholding rental fees until the end of the rental term. Shach, in Siman Shin Lamed Daled Sif Katan Gimel, quotes a Marami Titkin, printed at the end of the Mordechai and Horius, who rules that if a person rented a house and there is a plague that forced the residents of the city to flee, the landlord remains entitled to full payment, even if the renter hadn't paid anything in advance, as the landlord may claim the house remains standing and technically inhabitable the whole time. That's the position of Marami Tiktin, and the Shach argues, presumably holding, that this case is a classic Makas Medina, and just the opposite, the landlord would have to swallow the entire loss himself. And this is a position of the Taz as well in the beginning of Shin Lamed Dalet. So to summarize, in a Makas Medina situation where a property is theoretically inhabitable, but a raging war or pandemic prevents the renter from using the property, according to the Ravan, the tenant would be responsible to pay for half of the fees, regardless of whether he prepaid or not. According to Machan Ephraim, if he prepaid, he would not be entitled to a refund. If he did not prepay, he would not be liable for anything. According to the Marami Tiktin, the tenant must pay in full. According to the Shach and the Taz, the tenant pays nothing. In practice, there does not appear to be a clear consensus as to the bottom line in halacha. In a volume of the Emek HaMishpat series, a recent multi-volume work on Choshen Mishpat matters, written by Rav Yaakov Cohen in Eretz Yisrael, he addressed summer rentals in the north of Israel during the 2006 Second Lebanon War. As the war broke out in the summer, many people who had rented summer cottages in the Galil and the Golan were forced to cancel their reservations. In that situation, this Rav Cohen ruled that if the renter did not prepay, he could not be obligated to pay, because even if one were to accept the position of Marami Tikton, that the house is available the whole time and there's no Makas Medina exemption, here there's a clear umdana, clear presumption that no one would rent a property under such circumstances. And anyway, according to the Shach and the Taz, no money is owed. If, however, the renter did prepay, the landlord could not be forced to refund the money, as he would have the right to claim that he holds like that those positions that entitled him to the funds. This is based on the notion of kimli. In a situation where there's an unresolved dispute between halachic authorities regarding a monetary matter, the party holding on to the funds may claim that he subscribes to the position most favorable to him. Since anyway, he's a muchzak, he's in possession of the funds, and hamotzi mechavera olav haraya, the burden of proof rests upon the party that seeks to remove funds from the muchzak. Nevertheless, he concludes that it may be appropriate to reach some kind of a compromise and refund a portion of the advanced funds, especially as one could argue that a house in a war zone that could be hit by a rocket at any moment may be considered a flimsy, uninhabitable house, no different than a house that burns down. Rav Avadi Yosef Toledano, a grandson of Rav Avadi Yosef, a member of Usher Weiss's Beth Din, in Shuvas Meisha Mishpat Chelak Aleph Siman Mem Zayin, dealing with a canceled wedding hall rental after Operation Cast Lead, is more favorably inclined to leaving money with the muchzak, whereas Rav Usher Weiss himself, Chelik Beis Minchas Asher Siman Kuf Kaf, emphatically believes that halacha follows the Shach and the Taz, and even if payment was advanced, it would have to be refunded. In light of this analysis, it would seem that in most rental situations impacted by the current pandemic, whichever party is holding on to the money could not be compelled to refund or pay the funds. In the case of the Florida Pesach rental, the owner of the property could not be forced to refund the deposit, as he could claim that he holds like the Machan Ephraim or the Marami Tikton. And even if there was a ban on out-of-state rentals, maybe he could claim that he could have rented it out just as well to another Floridian. At the same time, that does not mean that holding on to the entire payment would be appropriate, given that according to many authorities, the landlord would not be entitled to anything. And perhaps a partial refund somewhere in the range of 50 to 75% would be appropriate. I saw recently a recently published collection from the Beth Din of Pesach Frank, in which they ruled regarding an unrealized rental after the 1929 riots in Hebron, where all the Jews were forced to flee out of Hebron, and the landlord claimed that he was owed unrealized rental fees for the time after the tenant left. So there they compromised that he should receive 2/3 of the fee. If no payment was advanced in our case of the Pesach rental, then presumably the renter cannot be compelled to pay based on the Shach and the Taz, other than costs that were already incurred by the landlord for the rental. Even there, it could be that a compromise would be in order. Payment for a wedding hall rented for a canceled reception may be different than the case of the canceled home rental in two ways. On the one hand, once state and local governments ban gatherings of more than a few people, wedding halls are unable to provide the services they were contracted for, and no one else could have rented the facility instead. And this may be more analogous to the case of the burned down house, where everyone would agree that the proprietor is not entitled to payment. However, given that a wedding hall rental fee typically covers the salaries of other employees and service providers, that portion of the fee may be subject to the rules of Makas Medina as they apply to employees, as we'll discuss in a moment. If a caterer already ordered food, then presumably the Bali Simcha would be responsible to cover those out-of-pocket expenses incurred by the caterer. As far as employment situations go, the general principle in halacha is that if there's an onus, an unanticipated situation, that neither or both of the employer and employee could have anticipated, they're both on the same footing in terms of anticipation or non-anticipation of this event, then the employer owes no salary for work not performed. However, the Mordechai, Bava Metzia, Siman, Shin, Mem, Gimel, writes as follows. I'll just bring it up on the screen. Mordechai writes, Im habitol shel hamelamed, machmas gzeres hamoshel shabeir. If there's a Rebbe, a teacher, who's unable to teach because of a government edict, in that situation, that's considered makas medina, and the employer, the balabayis who hires a malamed, must pay the salary. Hagos Ashri Parak Vav Vav Metzia Siman Vav says no saying lo kol skaro. He has to pay the entire salary. The Ramah quotes this Mordechai in Choshen Mishpat Shin Kaf Aleph, cross-references it in Shin Lamed Dalet about employment contracts. Simple understanding of the Ramah is that any employee who is unable to perform due to a Makas Medina situation is still entitled to full compensation. This is a position of Shach and Taz. The Sma, Shin Kaf Aleph Vav, Shin Lamed Dalet Beis disagrees. He thinks that doesn't make sense. And more mistaber, more likely, is that both the employer and the employee should share the loss split at 50-50, and the employee would be entitled to 50% of the salary he should have received for the job that he's unable to perform. And Rav Asher Weiss points out this could be dependent on two different girsos, two different versions of the Mordechai we just saw, whether it says ha hefsed shel balabayis, that the employer has the loss, or hefsed, or a loss. The loss would imply that you have to pay the full salary. A loss would imply that you meet somewhere in the middle. Just briefly, there is a third position in poskim of the Nesivos, Shin Lamed Aleph Sif Aleph, who argues that the Mordechai's case is limited to that of a Rebbe, of a Melamed, because of the unique situation that a Rebbe has in halacha. As a matter of halacha, you're not allowed to pay someone for teaching Torah, just as you're not allowed to pay a doctor for healing, which is why Rebbeim and doctors should be in the same salary bracket in an ideal society. But given that you're not allowed to pay a Rebbe for teaching, the only thing you can pay him for is babysitting. In that situation, the Mordechai, the government edict was that you're not allowed to teach Torah. Babysitting was fine. So since he was only contracted to babysit, he could do his job. That's why you still have to pay him his salary. But any other situation would not be affected by the Mordechai's position and would be treated like a generic ones where the employee is not entitled to any compensation. Just to conclude, I'll take another 3 or 4 minutes and wrap this up. In the contemporary Sefer Mishpat HaPolim, the author writes that the dispute between the Ramah Shach Taz against the Sma remains unresolved. Whoever's holding onto the money can claim Kimli and cannot be held accountable to return it. Rabbi Bleich, in a piece in Contemporary Halachic Problems, Volume 4, at the time of the Gulf War, writes that most poskim assume, like the Ramah, that an employee would be entitled to full wages. Many quote the Sefer Zikaron of the Chasam Sofer, page 37, which you have in the packet we sent out earlier, which is published posthumously, but it's the writings of the Chasam Sofer himself about certain personal events. He writes that in a situation of war, he himself paid the Malamdim full salary, but he felt that he couldn't obligate others to do so, and therefore it was appropriate to compromise 50-50. Now, the Chasam Sofer there himself seemed to think that the 50-50 compromise is actually, push comes to shove, what the din requires. But many take this Chasam Sofer to mean that we should really be operating in the spirit of compromise when dealing with unrealized wages and employment opportunities. Rav Asher Weiss points out, as well as others, that there's another factor to add to this equation, that of poel batel, that there is a concept in halacha that a person would be willing to take a pay cut of a certain percentage in order to not have to show up at work. So this applies to most workers in certain situations. Taz writes in Shilam and Gimel, it's a 50% cut. But if you're calculating what you would hire an employee in this situation, Poel Batel would come into the equation as well. So if you're starting with a 50-50 split, Poel Batel may knock it down somewhere in the 25, 30, 35 range as well. Now, presumably, any such calculations would take into consideration expenses that an employee does not incur from not working. If you hired a driver and he doesn't have to pay gas, tolls, wear and tear, so that wouldn't come into the equation. You'd be, if you're going at the 50-50 split, you would deduct that before making your cheshbonos. I'll hand over the floor now to Professor Saiman, and hopefully we'll have time to tie up some loose ends before we conclude.
Okay, let me just briefly introduce Professor Saiman. Professor Chaim Saiman is a professor of law and chair of the Jewish Law Department at Villanova Law School. Most recently, and I think most prominently, he's the author of the excellent book Halacha: The Rabbinic Idea of Law, published by Princeton University Press. And he's an old friend of mine, and I know him and have the pleasure of dealing with him more regularly these days because he serves as a Dayan at the Beth Din of America. It's a pleasure to introduce Professor Saiman.
Thank you. And I'd like to reiterate the words that both Rabbi Weissman and Rabbi Zylberman said at the beginning. I think to me, this whole experience has been a tremendous lesson in anivus, both at the personal level and at the social, communal, and really human level. So I'm going to I'll share my screen now and kind of use a PowerPoint to walk through a number of these questions from the perspective of American law, and with some, of course, references and comparisons to what I see going on in halacha. So let's start with the background. In American law, or the Anglo-American tradition, contracts are typically thought to be a strict liability regime, which means that you have to do what you promise to do. The reason for this is that, and I think there's some difference between the way American law and halacha think about this, is the centrality of the document itself, of the thing we call a contract. In other words, ordinarily, parties are expected to use contract terms to contract around unexpected events. So if I have to deliver you a ton of apples and the bridge is out, I should have said in the contract, I will use my best efforts or reasonable efforts to deliver the apples, or say, unless prevented by flood. And if I don't say that, then typically the condition is thought to be absolute. So things like conditions, limitations on damages, the structure of contracts, and we'll talk later about force majeure clauses, which are provisions in the contract that expressly talk about unplanned contingencies. Those are generally thought to be the tools to use for stuff that's unexpected. And here, I think American law is more interested with its doctrines of the lawyers don't understand what the parole evidence rule is, extrinsic evidence, four corners doctrines. There's things that really look towards the language of the contract and try to shut out other assumptions. That is the governing assumption in American law, I think, to a stronger degree, though not absolutely so, than in halacha. And that really sets the table, so that the default assumption is that if you didn't provide for it in the contract, you're going to be held liable to do it, even if something that is not your fault happens. We might think about this as a question of the degree that there's a claim of onus in Tanai versus the contractual language. Now, over time, two doctrines about unanticipated changes have developed. We'll talk about both. One is called impracticability, which is typically invoked, and you heard this in Rabbi Michoel's presentation, the halacha kind of thinks of them together, by the party who undertook to provide a good or a service that has either become impossible or more costly to provide than anticipated. And then the flip side is called frustration of purpose, which is typically when there's a payment, one party has a payment obligation to take, let's say the Pesach rental or whatnot. It's just that that thing is now worth significantly less. The performance is worth significantly less to that party than assumed. So the birth of the impossibility doctrine, and we'll talk about the change between impossibility and impracticability, is a famous case from England in the 1860s called Taylor versus Caldwell. What happened there was they rented out, no longer exists, but Surrey Gardens in London, which was a big kind of music and exhibition hall that you see here on the slide, and it burned down. So when it burned down, the plaintiff Taylor said, listen, I incurred all sorts of expenses in putting together these shows and advertising them, etc. And now it's not going to happen and I'm out. You, Caldwell, agreed to provide me this space. You can't do that because the building burned down. You owe me the money. That's the basic structure of the suit. Now, on prior law, it would seem that the plaintiff would have won because Caldwell didn't have any contractual provision saying, unless burned down or something like that. And therefore, it was thought to be that the obligation was absolute. Nevertheless, in this case, the court basically imports from the civil law, from the Roman law, an idea that comes to be known as impossibility that says, well, if it's impossible for him to perform, he is excused, and it goes through and says this has to be one of the rules of law. It says, of course, that there has to be some kind of implied assumption on the conditions. As it's been developed, the questions about this doctrine have typically been around the question of foreseeability. In other words, which Michoel mentioned as a halachic consideration as well. Meaning you could ask, well, who should have foreseen this risk? Or if nobody can foresee the risk, the way current law thinks about it is, which party is in a better position to absorb and maybe insure for this risk? So here we would say that, while the owner of the gardens probably had fire insurance or may have had fire insurance for the building, but the risk of the event not happening due to fire is probably better insured by the plaintiff, by Taylor here. And that sort of thinking has kind of come up more. So the questions of foreseeability and what lawyers call cheapest cost avoider are often mixed into these discussions. If we look at the restatement written in the 60s, a sort of, not exactly a code, but something close to a sort of authoritative view of American contract law, it lists basically 4 elements for impracticability. That the unexpected event must have made performance impracticable, i.e. it burned down. We'll talk a little bit more about it in a second. The event must be a basic assumption of the contract, right? So not any side points, but something that sort of really speaks to the essence of what this contract is about. It must have occurred without fault of the party seeking to be excused. And number 4 still leaves room to contract around this, we'll talk about shortly, which is the party seeking the excuse should not have undertaken a greater obligation than the law itself imposes. And we'll see this is a frequent source of litigation. When we go through it, there's basically 3 very well-defined categories that are well-known, and then one where all the case law is, because that's the most in doubt. So the obvious cases of basically impassibility is if one of the central parties to the contract has died or is incapacitated. If a thing necessary to the contract has been destroyed, that's the case of the building being burned down. And then quite relevant to our situation, prevention due to government regulation, which you saw in the halacha is an important consideration as well. So if the government prevents this event from happening or prevents performance, that is a kind of very recognized form of excuse. But most of the litigation centers around this question, other unanticipated events, and we'll see an example of that in a moment. So the other major case in this area is the case from 1966, transatlantic financing versus the United States. This is to show you how different times were. This was a contract for the U.S. where the U.S. government was shipping supplies from Texas to Iran. And the way, right back in the 50s. What happened was they were anticipating to go the short way. In other words, across the Atlantic, through Gibraltar, across the Mediterranean, through the Suez Canal, around the Sinai Peninsula, and into Iran. Now, of course, as we all know, in 1956, the Suez Canal was closed because of the war. So they had to go the long way across, around the Horn of Africa and all the way around. And basically, the shipping company sued the US government, that here is not functioning in a governmental capacity, but simply as the client, for the extra money it cost them to sail what was basically a 30 or 40% longer trip than they were anticipating. So this comes to the DC Circuit. And the DC Circuit, Judge Scully Wright, if those of know the name, one of the kind of important jurists of the mid-century, basically says there are kind of three factors we look at. One is that something unexpected must have occurred, and that happened here. The Suez Canal was closed. But then he ultimately rules against the shipping company and for the United States for these reasons. And these become very important in sort of modifying and shaping impossibility doctrine. First, he says that the risk of the unexpected occurrence must not have been allocated by either agreement or custom. In other words, the first thing you do is look into the agreement. Does the agreement say who should pay or who should bear the cost of this unexpected thing? And if not, we look to commercial custom and practice. And what he says here is, look, it's up to the shipping company to decide how to ship, what routes to travel on. They bring in evidence that everyone knew the best route was through Suez, but that the other route was understood to be a backup route. And therefore, when it says that this was discussed, in the industry at the time, people knew about this. And therefore, those are reasons to think that the risk ought not be allocated to the United States, to the client, but to the shipper. The third thing he talks about is that the contingency must have rendered performance impracticable. And he says, look, there was nothing impractical here. They could have sailed the long way. In fact, they did sail the long way. It's just more expensive. It's not impracticable. So when you put them together, he says, listen, as between a consumer of shipping services and a shipping company, we expect the shipping company to know more about routes, to know more about costs, to know more about these things. They then bring in evidence that it was known that something in Suez might happen. It had happened before. It happened in Panama, right? The idea of canals being open is not totally unexpected, and therefore the risk is allocated to the shipping company rather than to the United States. The way some scholars think about this is this word impracticability is supposed to be somewhere between impossible on the one hand and impractical on the other. In other words, merely because something is impractical or more expensive than anticipated or less desirable than anticipated is not a reason for excuse. On the other hand, the language moved away from impossibility. It doesn't have to be like impossible. It just has to be like considerably more difficult than anticipated, typically by orders of magnitude, rather than sort of market assumptions. So if you look here in the way the restatement talks about it, it will be something like this: a severe shortage of raw materials or supplies because of war, embargo, local crop failure, unforeseen shutdowns. That might work, but changes in degree of difficulty due to expense, increased wages, higher raw material costs, etc., does not. This is, not so different from the difference between a mazacha kagaram and a makis medina that we see in the halacha. I think it tracks pretty well. The second doctrine is called frustration of purpose. And the difference here is slight, but it helps kind of organize things. In frustration of purpose cases, the question is not, can the service be provided? But as Rabbi Michoel said, typically one side could say, go take it, it's not worth as much. And the case for this, and I found that, even people 30, 40 years out of law school tend to remember this case, so it's worth talking about, is Krell versus Henry. Krell versus Henry was a case in the very early 1900s that surrounded the coronation of King Edward VII in 1902, I believe. And there was a route planned, and it was publicized. And then immediately, people wanted to rent basically spaces in windows, in rooms, in apartments, overlooking the parade route, because everyone, of course, wanted to see this. What happened was the king got sick, and they had to cancel the coronation. They moved it to a later date. And someone had paid what was for then a lot, 75 pounds then. I kind of did some quick and dirty internet. This is something in the order of $10,000 to rent the rooms for 2 days on Pall Mall in the kind of central square in London to see this thing. And now basically this is like the Pesach program. The guy rented it says, I don't want it. And the guy and the owner says, go take it. I'm not disturbing you. So the court then, again, it applies some of the language that it used in Taylor versus Caldwell and says, no, this is frustration of purpose. And everybody understood, it was very obvious that there's one and only one use for this, that the rates reflect that the timing, and if the event doesn't happen, then we're going to excuse Henry from paying the rest of the amount to Krell. Probably worth noting here, and this has to do with like the sort of American law way of dealing with the muhsa question, is that the total contract was for 75 pounds, which again is something in the order of $8,000 to $10,000 today. Henry had made a 1/3 deposit. And the case here is really Krell suing for the extra 50. Henry did not make a claim for the 25 that was already paid. In terms of the case, not know why. And one question to think about is whether that matters. Here too, we want to think about, was it foreseeable? In fact, some scholars wrote that a few years before was Queen Victoria's 50th Jubilee celebration that also had a parade route, but was also pushed off. So maybe we could think of the degree this is foreseeable and whether that should have mattered. Another issue that comes up in subsequent cases is this question of license versus lease. And here I think there's an interesting contrast to the halacha in the case of Schiras Batim. In both Krell versus Henry and in Taylor versus Caldwell, that was the theater, the music hall, the court goes out of its way to say that these were not leases, but licenses. And these were permissions to use rather than a lease. In cases that came out of the Second World War, there's a famous case where somebody rented property in Los Angeles to sell cars as a car sale. And then, of course, in World War II, they stopped producing cars. So the person undertaking the lease basically said, I shouldn't have to pay because no cars can be sold. And there, the court said, no, a lease is really a sort of fractional ownership. And basically, you've now taken possession of this property. You can use it for whatever you want. There's no restrictions on it. And therefore, the risk of an economic downturn effectively goes to you. We heard a little about this in the halachic discussion about the degree of length and maybe the degree of assumption. So I think an important feature of both Krell versus Henry and Taylor versus Caldwell that they were both very short term and both for very specific things, in which case you could say that the risk of loss maybe did not fully transfer to the renter. If we look at the elements of frustration, they're very, very similar then to impracticability. The main difference is the first one, which is just not conceptually different, but it says that the unexpected event must substantially frustrate the principal purpose. In other words, so the court here has to figure out what the purpose is it frustrated? And of course, it must ask whether it's a basic assumption of the contract. Now, in this area, I would say more than in most areas of contract law, things are pretty unsettled. Maybe not in quite the way you heard in the halacha. In other words, everyone can state that the rules that we just stated apply, but most of the play in the joints goes into what was foreseeable and by who, and who should have been able to predict the risk, and did they allocate it by contract or not? Now, sometimes it's really clear. Someone will say, even in the case of flood, you have to do this. But we've seen cases where, maybe to the naked eye, something wasn't allocated by contract, but sometimes the court wants to do it anyway. In a fairly well-known case by Judge Posner from 1986, basically and most of these cases come up in long-term supply contracts, often in the energy industry. So this is one of these. Basically, we have a local power plant contract for a 20-year contract to buy a certain amount of coal from a certain coal mine. And the contract had a one-way escalation clause. In other words, it said that the price can go up if such and such events occur, but it did not have a clause that allowed the price to go down. It then turned out that the price of coal was under the contract was much higher than could otherwise be attained on the market. And NIPSCO, which was a Northern Indiana power company, came and said, force majeure. And the court said nothing doing. And in Posner's language, the force majeure clause is not intended to buffer against the ordinary risk of the contract. In other words, and what he says is, look, if you have an escalation clause that's only one way, you have, by contract, allocated the risk by saying any risk of it getting cheaper is on one party and one party alone. And this is an example, probably at the very edge. I think you could clearly see other judges on these facts coming out separately. This is sort of very consistent with Posner and the law and economics school that he represents. But that price allocation terms can themselves be seen as allocation under the contract. More common to be thought of in terms of contractual allocation are what's called force majeure clauses. The older language is to think of them as acts of God. The force majeure language probably says to capture more things like terrorism, strikes, things that you wouldn't call acts of God. Now here, these can be written in very, very different ways, and therefore interpreted in very, very different ways. Some of them are very broad, and therefore give either party an out for many, many circumstances. For the one I have on the board here, taken from a case that came up after 9/11. So here it says that the party's performance is excluded for acts of God, government regulation, terrorism, disaster, strikes, civil disorder, curtailment of transportation facilities, or any other emergency beyond the party's control, making it inadvisable, illegal, or impossible to perform. So when I taught my students a week ago, and I said, okay, suppose we have a wedding case like what Michoel talked about, and we've got this force majeure clause, they concluded fairly easily that either government regulation or disaster or curtailment of transportation facilities or the catch-all of any other emergency beyond the party's control, and all it has to do is make it inadvisable, this would be a very good clause for, let's say, a chassan and kala seeking to get out of a wedding contract. By contrast, I then gave him another one. Taken from a different case. Probably, I don't think the drafters of this thought this to be more or less broader or more constricted. But as you look here, force majeure is defined as, riot, war, and invasion of foreign enemies. Okay, not that. Ionizing radiation, contamination, radioactivity, nuclear active stuff, not that. Earthquake, flood, fire, physical and natural disaster, maybe. And then strikes at the national level, industrial disputes. So my students, I think, correctly concluded that at least it would be much, much more difficult for a potential chassan and kala to get out of this contract, to get out of contract under this force majeure clause than under the other one. And the place you might stick it is, is this a physical and natural disaster? And I know in the insurance context, things like this are litigated and are being litigated now. So just maybe to conclude, with a little bit of some like the chassan kala wedding discussions that Michoel raised. And here we see that while the question of muchzakus is typically, in other words, who holds the money, I think typically in American law is less important than in halacha. I think halacha tends to give, I would say, greater deference to he who holds the money, whereas American law, of course, also has the idea that the plaintiff bears the burden of proof, but tends to kind of not put as much a thumb on the scale. In this area, I think that that is not as true. It's a little bit more similar. And we'll see that the type of damage that we're seeking probably matters as well. So if we take a very simple wedding hypo, and I imagine that on September 1st, the bride and the groom contract with the caterer for a May 1st wedding for, let's say, $100,000, and then the wedding is canceled due to the coronavirus and related government regulations. And now the caterer can show that the cost of not putting on the wedding is $85,000, and he seeks his $15,000 in lost profits. In a simple, ordinary breach of contract remedy, the caterer can obviously get the $15,000. That's probably a little bit more complex in halakha. So on what we've seen, whether we think this would probably be a frustration of purpose case, maybe an impossibility, maybe even the caterer can't put it on anyway, but even if he could, I think that, given what's going on, this is not a hard case to say that the bride and groom are excused, and therefore the caterer is not going to get the $15,000 in lost profits. Now we could change it and say that the bride and groom prepaid the caterer $30,000, and now they seek their deposit back in variation 2. I think here they would probably get their 30% back. Where it gets stickier, and Michoel alluded to this, is that now assume that the caterer spent $15,000 on raw materials for the wedding. So here, I think this is where the kind of muhzakus thing does come up in American law, in which I think if the bride and groom paid nothing, I think the caterer would have a very hard time getting the $15,000 out of them. But if he was holding on to some of their money, I think he'd much more likely be able to keep it. Although, of course, in variation 4, if he spent $35,000, in other words, more than the deposit, I don't think he would have a claim to keep all of it. He would have to set it off there. To conclude, American law has a harder time with the sort of yachloku, split the loss, that we see in the halacha. It's not really well tuned for that because it wants to allocate, basically wants to say who allocated the risk. It will sometimes expand the concept of restitution to try to get there, but that really much depends on which way money flowed and how much performance was done. Especially under force majeure clauses, the traditional doctrine is that you read them carefully and you follow them as to what they say. I would say a persistent source of litigation in this area is the relationship between what we'll call the common law defenses or excuses baked into impracticability and frustration and the force majeure clause. Does the force majeure clause totally preempt those and sort of erase them and you only look to the doctrine, or do those kind of work in tandem? Much of the case law is about that, and it tends to turn on how it's written. In a paper that is kind of forthcoming by 2 law professors, well-known contract scholars, they actually make the argument that in cases of, or in situations of wide-scale crisis, what we might call makas medina in halachic terms, courts actually tend to do much more split the difference than the official doctrine indicates. In other words, the courts tend to adopt something closer to halachic resolution than what the formal doctrines of the common law say. That's their contention. It would be very interesting to see if that happens, and maybe this is a place where some halachic thinking might be beneficial in the discussion and analysis of Anglo-American law.
Okay, thank you for Professor Saiman. Before we move on to anything else, I want to cover a very important point, which is the CLE code. The CLE passcode is coronation, alluding not only to the coronavirus, but also to the coronation cases. So coronation, C-O-R-O-N-A-T-I-O-N, I think I spelled that right. Coronation is the CLE code. You'll be getting a form where you can enter that code after the CLE is over. I believe it's set up so that when you end the meeting or you log out of this meeting, it'll automatically put you into that form. But if that doesn't work, we'll be sending out an email anyway with the link to the form. Okay, let's jump into some. Well, actually, before questions, Rabbi Zylberman, do you want to kind of tie up any loose ends relating to Professor Saiman or anything else?
I think we can move on to questions. I noticed that some of the questions that were asked deal with some of the things I would have tied up, so we can go straight to questions from my perspective.
Okay, great. So let me ask this question. I'm pulling from elements of different questions that people submitted, and I'll ask this to both of the panelists. Kind of how would you apply your presentations in the situation of, let's say, camps or play groups where parents prepaid, maybe they didn't even prepay, but they submitted forward dated checks. And then it turns out there's no play group or no camp. If you want to expand the question a little further, some of the questions I received, how do you relate that to yeshiva, where perhaps some people might complain that the intensity of the yeshiva experience with periodic Zoom calls or daily Zoom calls is not as intense as the services provided when you first signed up your kids for yeshiva this year. How do you think those kind of fill out? Before I actually do that, I just wanted to point out one other thing that's important to mention, and that is that the Beth Din of America handles these types of cases. We're open for business, and we're actually handling Dinei Torah via Zoom. So in the event that there is, in the event that someone has a controversy regarding these, you should be in touch with us. You could open up a file at our website. But more importantly, relating to that, it should be understood that the speculations and discussions in this webinar don't constitute legal advice and shouldn't be understood by anyone as a prediction of an outcome in any particular case. Every case has its own particularities and complexities, and obviously we're kind of talking here in theory, l'halacha v'lo l'maisa, and it's only once a case has been submitted to a Beth Din that gets to hear all sides of the story and all the details that are relevant to the case, only such a Beth Din could ever paskin on a particular case. So it's good to talk about these things. It's important to talk about these things, but everyone should understand this is not a prediction of any outcome in any particular case. We're not beholden to the specific shitas that we're discussing today. Okay, back to the question at hand. Camps, playgroups, yeshivas. Rabbi Zylberman, you want to talk first about that?
Yeah, I would just add to Rabbi Weissman's disclaimer that just as we're not offering legal advice, we're also not offering halachic advice. And my presentation should be taken in that spirit as an attempt to outline the issues, but in no way to draw conclusions. And even if we are open for business, we're not looking for people to argue about this right now. And it's probably better if people could engage in a spirit of pshara compromise and at least wait ad she'avor zam. We should hopefully be beyond this quickly. But many of these things should wait till we calm down and can deal with what we'll call the less significant issues as opposed to, unfortunately, what many of us are dealing with now. So Rabbi Weissman's question seems to break down into 4 parts. I'll try to answer as briefly as I can. The first question is one of post-dated checks. And what does that do as far as a person's status as muhsak? If we outlined earlier that a person may argue kimli, may argue that he can subscribe to a minority position in the event of a machlokas if he's holding on to the money, and the other party has a burden of proof to remove the money from him. So is a person who's holding on to a post-dated check considered to be a muhsak? Rabbi Ben Yaakov, senior died in the Beth Din in Tel Aviv, in an article originally in Tchumin, published in his first volume of Shuvas Mishpatach Yaakov Chelik Aleph, I believe it's Siman Yud Aleph, or Lamed Aleph. Rabbi Ben Yaakov argues that in Eretz Yisrael, where apparently it's illegal to cancel a post-dated check, the person holding on to such a check is muhsak. But it's highly questionable and probably not the case that the same analysis would apply in America. Here, given that there is no legal restriction on canceling a post-dated check until the date of the check has arrived, arguably, if a person has a legitimate claim that he doesn't owe the money, he would be in his right to cancel that check. Not advocating that in any specific situation. Anyone should seek counsel before doing that. But as a theoretical matter, before the date of the check or the payment has arrived, the person holding on, the person whose name the check is in, may still be considered the muhsak. Moving on to the question of playgroups. we would presume that the employees of playgroups and the proprietors of playgroups are considered employees in our analysis. We may segue to a related question in a moment, and therefore that should be subject to our analysis of employees are unable to perform their tasks under the current conditions. So if we would push some kind of a pshara, some kind of compromise to split the loss, so that range should be in the 25 to 50 range. I've heard of Usher Weiss say a couple times in recent weeks that if you consider the Powell-Buttel equation, as you mentioned, that the payment for such playgroup teachers should be in the 30-35% range as a ballpark figure. But that's where that would head. As far as camps are probably more analogous to a canceled Pesach program, where you sign up for service that is, as opposed to hiring a contractor, you sign up for a service that can't be provided if the government or state or local authorities aren't allowing camps to open. And then presumably people should be entitled to significant refunds subject to the following qualifications. If the camp had expenses that they already incurred in advance of opening in the summer, so could be that those expenses could be passed on to the consumer. If there's a clause that some kind of a no cancellation clause, you'd have to analyze the language of that clause and see whether that would still be subject to a Makas Medina exemption. As far as yeshiva tuition payments, I think the general consensus across the board is that so long as yeshivas are offering some kind of remote instruction, even if it may not be to the full liking of some people, may not be the same number of hours, but yeshivas are paying full salaries and providing as reasonable a service as they can under the circumstances, and in some situations perhaps working even harder than under normal circumstances, given the challenging realities of the time, combined with our interest, as Rosh Hashanah wrote in a recent tshuva, in keeping our yeshivas functioning, it would be unlikely that there'd be a substantial claim for any tuition refund. That's in distinction to ancillaries, let's say a meal plan or transportation costs, or kinds of goods, as opposed to services that may not be able to be rendered. So there may be a claim for a full or partial refund. Again, these things, as our institutions should be, hopefully are, and we believe are working in good faith, and we should cut them the slack to operate as such and work things out appropriately at the right time.
Okay.
Go ahead, yeah.
So I'd sort of reiterate what Rabbi Michoel says. A lot of these cases, there are no good answers because there is a loss, and I think and someone's going to have to eat it, and the question is who and how. And you do see, even in the American law cases, a kind of, though they can't quite push for pshara in the way that a Beth Din can, they do tend to try to encourage the parties to go there and sort of leave it off as a last resort. I don't think I would differ so much from what Michoel says. Obviously, in American law, yeshivas don't get any special, special thumb on the scale over anything else. But the first thing I would ask is with the playgroups, if the government, I mean, who is at least presumptively in breach here? At the moment, at least in the Northeast, it would seem that the playgroup can't operate. So it seems to me hard to understand how the leader of the playgroup can have a claim against the parents if they can't provide the service. Now, if we go to a place where the service can be provided, but the parent is a little bit hesitant because of the corona situation to send their kids to the playgroup and whatnot, then I think it looks quite different. And then it would seem to be that if they sign, let's say, a one-year contract, and now the playgroup can be opened and the government is not preventing it, and the person doesn't want to send because they're afraid, it would seem to be that they would have to pay at least presumptively, or maybe seek to find a replacement. If they're unwilling to, so then we get to what in contract law we call mitigation devices and cost avoidance. In other words, Is it the full cost of what they were going to pay being suffered, or are there other ways to mitigate? Is there some work or expenses that the playgroup, and I think the camp is not very different, would have provided that it's not providing? So those to me seem to be the questions. The fact that at the moment, at least, things are prevented by government edict, and therefore the service providers, the camps, and the playgroups can't provide it, seems to me to matter. The question of the online instruction, I've been not in the yeshiva, but in a law school, teaching online for a while. There are some cases out there. I saw some class actions of law students or maybe university students saying, we're not getting the same level of instruction. I think the courts will not go for that. As Michoel said, they're providing the service as they can. Typically there's not a contract between the student and the university that clearly lays out what the expectations are. But, meal plans, dorms, I think there's certainly what to negotiate there in terms of costs avoided. So that would be the way I think that would come out under an American law scene.
Yeah, I'll point out a few people asked this question. To what extent does mitigation play a role? You just touched upon it, Professor Saiman. Maybe I'll bounce that back to Rabbi Zylberman. In some situations, landlords might be on the receiving end of some bailout, or in the flood cases, they might be getting flood insurance. In this situation, some schools or companies might be qualifying under the payment protection plan or some other government bailout form of mitigation. And to what extent does that change the halacha here in terms of a paying parties ability to get their money back or not pay?
So I imagine that goes back to our introductory remark that Dina de Malchusa Dina needs to be taken into consideration. And if in practice the government is making whole certain things that otherwise would be collectible, you're not going to double dip, and you can't charge for what you're being compensated for anyway. But that would be a case-by-case determination. Let me just go back, and I want to make one more comment about some of the employment questions that were just asked. I saw on the Q&A list some people had asked questions about employees being at will and how that fits into this analysis. That is a very good question that we should have clarified a little bit earlier. Beyond the scope of our analysis now to fully flesh out how halacha views employees, there's a difference in halacha between a socher, a more classic employee, and a kabla, a sachir rather, a more classic employee, and the kabla, and a contractor. And depending on what the presumption of the contract is, or whether there is a contract, if an employee indeed is an at-will employee, then our discussions are largely irrelevant. But in many situations that we deal with, we have certain types of contractors, or people who are analogous to contractors, a school bus driver, or the play group, or someone who's hired to play a band at a wedding, or situations like that, where this kind of compensation for services not provided in a Makas Medina situation is relevant in halacha. Moshe has a chiddush, which may not be widely accepted, but Moshe writes it, that the default presumption of any employee is that absent a contract saying otherwise, he's not at will, and therefore, in theory, you can never fire an employee without clause, unless there's a contract that indicates otherwise. So that's a big chiddush in halacha. Moshe does say that, so to the extent that that's ever relevant, that has to come into consideration as well.
Okay, I'll add to that so one of the questions that came in is, to what extent does a Beth Din pay attention to or pay regard to a force majeure clause? And I think the answer there is similar. Beth Din will typically be bound by the expectation of the parties based on kol tanai sheb'mamon Chaim, and just like minhag socher, minhag medina will play a role, the local custom, so too will a contractual agreement between parties typically be binding, and the Beth Din will pay regard to that, will enforce that. Professor Saiman, another question that came in was, to what extent could COVID-19 be used, where appropriate, to extend a time of the essence clause? Does that change anything? Is that kind of the
Yeah,
same?
yeah. So let me just answer a few of the questions. First of all, as to employment, there are relatively few that I've found employment-based cases in the common law. My suspicion as to why that is touches on something where Michoel just said. Most employees in America are at will. And if you're at will, then you don't need anything as dramatic as COVID or pandemic or anything. You just be fired or not hired for any moment. When employees are not at will, they tend to have, this is at the higher end of the wage spectrum, they tend to have contracts with, sufficient protections for them. Also, these things tend not to be so long-term. A year is common, maybe 2, so that and so you're talking about relatively few people with long-term employment contracts that are not so long. So I think there's typically just not enough money there to generate lots of litigation on the employment context. With regards to mitigation, where this comes up, and I've seen in the cases, is with insurance. So there are cases that say something like this. There's a famous case where a contractor built a bridge for a county, and then a fire came and burned down the bridge. So the county never got the bridge. The contractor then says, yes, but as a restitution claim, as a quantum merit claim, I should get back the amount of kind of work that I put into the bridge. And the court there really expands the definition of restitution or unjust enrichment. Typically, we expect, in this case, the county to have actually accepted the enrichment. In this case, their claim is we didn't accept the enrichment, there's no bridge. But what courts have reasoned is, but because your insurance, you're insured typically to the point of where it's at, we're going to count that as a benefit to you that can then be returned to the contractor. So I assume, and if that similar sorts of ideas will come up in the cases when through various government programs, it's not quite insurance, but it has some aspects of that. But that may count for mitigation. But I am sure that will be litigated well. Just one point about I saw someone ask here about going forward. So. Maybe a global pandemic was not foreseeable until now, but now it certainly would be. For example, after September 11th, you see terrorism sneak into all sorts of force majeure clauses. So whereas before then, the United States has lived in a way where terrorism on domestic soil was pretty rare. So even if it's not in a force majeure clause, they might be imputed. I think today, if you have a force majeure clause without a terrorism exception, you're going to have a hard time seeking protection based on the doctrine of impracticability or frustration when you have a force majeure clause to say, listen, you wrote the clause. If you wanted terrorism in there, you should have put it in. I suspect that maybe not in the immediate aftermath of this event, but as we go forward, maybe 2, 3, 4 years down the road, a force majeure clause that has lots of stuff going on but doesn't have pandemic or virus or something like that might be read differently than one will be read right now when it was less expected. Reb Shlomo, the question you asked was, just remind me?
Extending a time of the essence clause in a contract.
Yeah, so I think that if the contract if we would say that force majeure or impracticability frustration applies to this contract, I think that would clearly allow, I have my suspicion, let me hedge a little bit, I think that would allow the time of the essence to be extended, because really what you're saying is performance is excused, and what we're excusing here is the timing condition.
Yeah, okay, let's just end with kind of one last question that was posed that's also forward-looking, and hopefully we can look forward to better times where we'll be able to gather once again in public spaces and at weddings and at simchas. This question was, if a wedding hall is requiring a large deposit for a wedding planned for 6 months from now, what do you do? I can tell you my answer is you probably try to find a different wedding hall, or you negotiate to pay only a small deposit, but I'll open it up to the panelists to see if they have any other thoughts on that.
I just want to understand the facts. The facts is it's been paid? Or?
No, it's more of an advice question. A wedding hall is requiring a large deposit to book a wedding 6 months from now. Given things as they are, I think maybe the answer is obvious. You just don't pay it, or you negotiate a lower amount. Any other thoughts on that?
Yeah, well, I had a student ask me that they had contracted with a wedding hall and they were making progress payments, and it's for September, so they think that the government regulation prong won't happen then, but and that the wedding can happen, but that they're not going to meet their like minimum targets of people, which they they had a contract for X number of people, and they're afraid they're not going to meet them. But I think if you haven't done it yet, then yeah, I think now wedding halls are probably it's a buyer's market for something a couple months out, and you should probably negotiate around it.
Yeah.
Even if we committed to not offering legal or halachic advice, common sense we probably still could offer.
Right. Right. Okay. And just to close things up, a few people asked us to define kimli. That was a phrase that Rabbi Zylberman used in his presentation. Rabbi Zylberman, you want to just give a one-sentence definition of kimli?
A person has the right to claim in a financial matter subject to dispute that he holds of the minority opinion in a way that entitles him to hold on to funds that he's already holding.
Great, thank you. Okay, let's close off as we mentioned with a parak of Tehillim. I'll recite it. You could all join me. This is for a refuah shlema, speedy recovery for all those out there who are suffering from COVID-19. We hope that that Hashem grants them a refuah shlema. Shir Hamalos Mimama Kim Krasicha Adonai.
Shir Hamalos Mimama Kim Krasicha Adonai.
Adonai Shema V'Koli Tiena Aznecha Kashuvos L'Kol Tachanunai.
Adonai Shema V'Koli Tiena Aznecha Kashuvos L'Kol Tachanunai.
Im Avonos Tishmarya Adonai Miyamod.
Im Avonos Tishmarya Adonai Miyamod.
Imcha Slicha L'man Tivarei.
Imcha Slicha L'man Tivarei.
Yivisi Adonai Ki V'sa Nafshi V'lidvaro Hochalti.
Yivisi Adonai Ki V'sa Nafshi V'lidvaro Hochalti.
Nafshi L'Adonai Mishomrim Laboker Shomrim Laboker.
Nafshi L'Adonai Mishomrim Laboker Shomrim Laboker.
Yachel Yisrael El Adonai Kim Adonai Achesed Barbeimo Fidus.
Yachel Yisrael Adonai Kim Adonai Achesed Barbeimo Fidus.
V'hu Yivtes Yisrael Mikol Avonosav.
V'hu Yivtes Yisrael Mikol Avonosav.
We thank you all for joining us today, and we hope to be in touch with more presentations in the future. Make sure to check out our content on our blog, Jewish Prudence, which is filled with Beth Din-related discussions of Jewish law, Jewish prudence, its interaction with secular law. If you found this CLE interesting, you'll find all that content interesting, and we hope again that everyone who is suffering during this time finds comfort and a refuah shlema. Thank you all.